just in case one of you were not able to make it here today, before giving you the oath, we could still add another juror to serve. But once we give the oath, we have to stay with the panel that we have unless we run into some other unforeseen situation. So with that, we'll start. April, if you wouldn't mind the oath.
Yes, Your Honor. Can you please stand and raise your right hands, please? Do you swear or affirm that you will diligently inquire into and carefully deliberate all matters between the state of Ohio and the defendant, Carl Wimpey, Jr.? Do you swear or affirm you will do this to the best of your skill and understanding, without bias or prejudice, so help you God?
All right, thank you. You may be seated. And then, ladies and gentlemen, our court reporter today and tomorrow will be Rose. She works in Judge Mandros's court, which is right next door. And as I told you, Kelly was going to be out today and tomorrow for the funeral from Judge Donahue, and Rose graciously volunteered to step in for us. So with that, we're going to start with the court's instructions to you. I will read you these instructions. They've been compiled over time to comply with the requirements for the court, and then we'll move into opening statements. So with that, ladies and gentlemen of the jury, for most of you, jury service is a new experience. Therefore, some words of explanation and orientation are in order to give you an idea of how to act and what to expect during a trial. All of those who participate in a criminal trial must do so in accordance with established rules. This applies equally to jurors, prosecutor, defense counsel, defendant, witnesses, court personnel, as well as myself. Therefore, that is why I read you these specific instructions. Now, counsel will present the evidence through the questioning of witnesses, the offering of exhibits, and stipulations, if there are any, as well as the introduction of evidence is done according to specific rules, that is, the rules of evidence. Now, the judge enforces these rules and determines what is admissible and what is not. So from time to time, the court will sustain an objection to a question or to a certain piece of evidence. You are instructed now not to speculate why the court may have sustained such an objection, nor are you to speculate as to what an answer would have been to a disallowed question. You, as the jurors, will be the sole judges of the facts in this case. The credibility of the witnesses, that is, the believability of the witnesses, and the weight to be given to the various parts of the evidence. Later, the court will furnish the rules of law in detail, which you will apply to the facts that you find to reach your verdict. It is your sworn duty in this trial to accept the law as I give it to you. Now, the general procedure for trial is as follows. First, the state and then the defense will outline for you in an opening statement what they expect that the evidence will show during this case. The opening statements are, in effect, the lawyer's preview of the case. It is very important that you understand and keep in mind these opening statements are not to be considered as evidence themselves. Now, following opening statements, each party may then present evidence, with the state going first, followed by the defense. Thereafter, rebuttal evidence may be offered by the state. The trial will then conclude with the arguments of counsel, the instructions of law to you by the court, and then you will retire to consider your verdict. Now, it is, of course, essential that you be fair and attentive throughout the trial. Do not discuss this case amongst yourselves while the trial is still underway. Nor should you discuss this case with anyone else in or out of the courtroom while the trial is ongoing. Nor should you permit anyone to discuss this case with you or in your presence. In fact, you should not, and you must not, form an opinion in this case until all of the evidence is in and until you have been instructed on the law. To reach an opinion prematurely would be unfair and improper. Now, it may be difficult for you to understand why you may not discuss this case amongst yourselves as the trial goes along, but please accept it when I tell you that your minds should remain open until you have heard all of the evidence, the final arguments of counsel, and the instructions of law. You should explain this rule prohibiting discussion of the case to your family and friends, so they will understand and will not attempt to question you. Of course, once this case is fully concluded by verdict, you will be released from this restriction and will then be free to discuss or not discuss this case with anyone as you may wish. The court also instructs you as we begin not to converse about the case during the trial with the prosecuting attorneys, defense counsel, a defendant, with any witnesses, or in fact with anyone who has any connection to this case. In fact, if anyone If you stress anyone attempts to discuss this case with you, you should bring that fact to the immediate attention of the bailiffs. Now, it has become the practice of this court to permit jurors to take notes during the trial if they so wish. This is a practice that the court neither encourages or discourages. I simply indicate to you at this time that the court will supply tablets and pens for those of you who want them. Now, a few cautionary words about note-taking are in order. First, and most important, you do not have to take notes at all. And if you do not, you should not feel in any way that you are a less attentive juror than one who does take notes. The decision to take notes is strictly a personal one. Some people concentrate better in a trial situation if they take notes, while some are distracted if they try to take notes and thus prefer not to. Some of you may take extensive notes, some of you may take sketchy notes, some of you might start out taking notes and stop, and obviously some of you may take no notes at all. There is no preferred method. You should keep in mind that note-taking, even if extensive, is in no way a substitute for a verbatim record of the trial or any smaller portion thereof. Also, if during deliberations the jury were to ask for a copy of the transcript, that cannot be provided. Now, no juror, note-taking or not, should regard any juror's notes as definitive. In fact, later, during deliberations, the recollection of a note-taking juror as to certain evidence is to be regarded as no more accurate than the memory of a non-note-taking juror, and that point cannot be overemphasized. So the tablets and pens are offered for whatever assistance they might provide. Also, some procedural words about the tablets. At each recess, please leave your tablets face down on your chairs, and they will be protected by the bailiffs while you are gone. Also, please make sure your juror number is on the back of your tablet. At the end of the trial, that is, after closing arguments of counsel and legal instruction, note-taking jurors will be permitted to take their tablets into the jury room for deliberations, to use it simply as a tool to refresh their own memories, in accordance with all the instructions that I've just given you. Now, also, you should understand that you are to consider as evidence only that information which is presented to you in this courtroom. Specifically, you are instructed not to read, view, or listen to any report of this trial in the media, nor should you permit anyone to read or discuss such reports in your presence. It is a fact, unfortunately, that such reports are sometimes wrong, incomplete, or inaccurate. In the same vein, you are to make no effort whatsoever at any time during the trial to investigate this case on your own, or to visit any site referenced during the trial, or to obtain any information about this case from outside the courtroom sources. And naturally, you are not to permit anyone else to offer you such outside data or information. Once again, if you should acquire any information on any of these matters, or in any other way, or if anyone attempts to tell you anything about this case outside of the courtroom, you should bring that fact to the immediate attention of the bailiff. As I instructed you yesterday, this does include search engines such as Google or any other similar type of search engine on your cell phones, your personal computers, your tablets, or anything of the like. Also, please do not discuss this case by way of social media or any other social form of communication such as Facebook or Twitter. There will be plenty of time to take care of that after this case has been concluded by verdict. Now, I will attempt to remind you of the general guidelines and rules of juror behavior at each recess. If overlooked, however, I'd like to stress that these rules apply at all times until a final verdict has been rendered and you have been discharged. Now, before we hear the opening statements in this case, I'd like to advise you preliminarily that a criminal case begins with the issuing of an indictment. An indictment merely informs a defendant that he or she has been charged with a crime or crimes. The fact that an indictment has been issued may not be considered for any other purpose. A plea of not guilty is a denial of the charges and puts at issue all of the essential elements of each of the offenses. The defendant is presumed innocent unless his guilt is established beyond a reasonable doubt, which I will define for you more fully once you have heard all of the evidence in this case.